Welcome, folks. Today we're going to be talking about an issue that comes up in almost every workplace case I do, almost all of them, and that is this idea of duty to accommodate. Now, many people have heard this term, but maybe you're not sure completely what it means, where it comes from, how far it goes. By the end of today, our little session here, you'll have a better understanding of how it works in Canadian employment law, this idea of duty to accommodate, when it will apply to you, and when you can rely on it to enforce your rights. Okay, let's dive in here. So why does this topic matter? The duty to accommodate is one of the most important protections for workers under Canadian human rights law. Canadian human rights law is made up of the Canadian Human Rights Act that applies in federal spaces and the various provincial Human Rights Act that will apply to most workers across Canada based on the province where you reside. Now, it often comes up in cases involving disability, but it can apply to other areas of discrimination like sex discrimination and also family status discrimination, of which I've done a number of those cases recently. There are a lot of myths around the concept of duty to accommodate. Some employees think employers only have to make token efforts. That's not true. And some employers believe they don't have to change their standards or policies at all. The truth is really somewhere in the middle, but with a strong leaning towards protecting the worker. One of the reasons I really enjoy doing work in the disability and specifically the employment field is that the law is quite favorable to workers in Canada, believe it or not. So it is good when you have a case where you can go to court and have a lot of the law be on your side. Okay, let's do this. What is the duty to accommodate? At its core, the duty to accommodate is a legal obligation requiring employers to adjust workplace policies, environments, remove barriers that prevent employees from fully participating in the workforce. Sorry, the workplace, not the workforce. It's not just a nice to have thing or a courtesy. They actually have a legal requirement under provincial and sometimes federal human rights codes, and it applies to many protected grounds of discrimination. Commonly, though, those are going to be areas of disability, religion, family status, gender, and even sometimes cultural practices. So how far does it have to go? How far do employers have to go? Employers, sorry. The law says that they have to make accommodations as long as you can prove that you have a protected ground. They have an obligation to accommodate you up to the point of undue hardship. This means they have to make real serious efforts to try to accommodate you, unless doing so would cause serious difficulty to the employer. This will be different. What is undue hardship for one employer will be very different for another. It all depends on the context, the size of the employer, the type of accommodations that are needed. So there's not a one rule. There's not like a common rule that's going to apply in all situations. The rule is going to be that it has to be undue hardship for the specific employer. So it's undue hardship is not like, it does not include things like a minor inconvenience or extra cost. It's a very high bar. So just because there's some inconvenience or costs, that will not meet the criteria of undue hardship. Factors include are going to include, like, it has to be a high financial cost for this employer. Impact on health and safety would be another reason where it could be undue hardship, and this obviously the size and resources of the employer. So large companies, governments have more, they're expected to do a lot more than a small employer with a small business. Now, what are some examples of accommodations that you can look at here? It can take many forms. Common accommodations we see are adjusting job duties, providing lighter work, allowing flexible schedules, different shifts, offering remote work options, providing assistive technology. The key point about accommodations is they're removing barriers so you can do the job to the best of your ability. That's the ultimate kind of definition of what we're looking at. So as far as employees, what are your employee responsibilities? Well, accommodation is a two-way street. So this isn't a situation where you can just put all the effort onto the employer. You are required to participate in good faith as well. You have to let the employer know. They have to be put on notice that you need accommodation. You don't have to give every detail about your medical condition, but you do have to provide enough information so they know they have to be able to know what your limitations are and the type of accommodations that you would need. Most importantly, you have to cooperate in the process. That means being flexible, responding to reasonable proposals from the employer, possibly undergoing medical assessments arranged by the employer if it's reasonable, and getting the employer information and clarifying information for the employer. I've seen many cases fail where the employee really did not act in good faith in the process and did not get even though the accommodations were reasonable or that they could be reasonable, the employee did not get enough clarifying information to help the employer make decisions, and courts and human rights tribunals will hold that against you and basically dismiss your case. Common mistakes that we see with employers, this is so where you see things go off the rails a bit is generally when are we making allegations that there was a failure to accommodate? Typically, it's going to be dismissing requests without any proper investigation. I had a case today. I'll talk about that after we're done this presentation. But one of the key allegations was that the employer was on notice that there was a possible duty to accommodate, and they have to do a reasonable investigation into that. Even if sometimes the employee has not overtly stated they need the accommodations, the employer can still be on notice and have an obligation to look into it. So this is always something that will catch employers where they have not done an investigation or looked into whether an investigation was necessary when they're on notice that an employee could be in need of accommodations. Sometimes employers will just rely on blanket policies rather than realizing you do have to accommodate, and that could mean for certain individuals who have a disability or have something in need of accommodation for a protected ground of discrimination, like you may have to adjust the policy for them. Employers often don't want to do that. They want to apply it across the board to everyone, but that's not how it works with accommodations. Sometimes it will require them to amend their policies, do things differently. Okay. Another reason would be sometimes they just don't talk to the employee at all. They don't engage meaningfully with the employee to see like what possible accommodations could there be, better understand where the employee is coming from. So just cutting the employee out altogether, not having a conversation with them, not responding to their inquiries, it will be another kind of black eye. That's a mistake for the employer. It'll make them look very bad. They have to show that they've put in some reasonable effort here. So when they are not putting in effort, when they're not communicating with the employee, it is a very bad look. These kind of things can put the employer in violation of the law. And again, as long as the employee you've acted reasonably and you have acted in good faith, if you have a legitimate human rights issue, the law is on your side. But again, like I said, you have to make sure that that you have a legitimate case and that you've acted reasonably and in good faith. Sometimes that's not always the case, but if you have, the law is on your side in a lot of this. So what can you do as an employee? Well, if you are someone who needs accommodations, there are steps you have to take to protect yourself. Number one, you don't want to rely on a court finding that the employer should have done something because they were on notice. You want to actually like make it clear that they were on notice. Don't rely on a court having to say, well, the employer sort of knew, even though you didn't tell them. You don't want to be in that situation. Just come out and tell the employer that you need accommodation and give them the details they need. Create a record of it. Don't just tell them verbally. Make sure that it's documented. Either you document it as part of the notice, or if you talk to someone verbally, you follow up with them with an email or text to get it in writing that you have notified them about the accommodation. Suggest possible accommodations that could work. Now, they have to be reasonable. And sometimes people ask for things that just aren't reasonable to do. So I would recommend you speak with your doctor and try to come up with things that are reasonable for you to do. What's not reasonable? Like sometimes people will say, well, I need a different boss. That's the accommodation I want, or I want this other job. Those are not reasonable requests. You can't ask for different management personnel, this type of things. You can't ask for a new job. Those are not reasonable. Other things, they have to be something that could be done within the context of your job that would still allow you to productively work in the job without like the employer does not have to give you accommodations so that it would result in you doing like meaningless, futile work or completely unproductive work. Again, it's hard to give hard and fast rules. It's going to be case by case, but that's why sometimes you should get legal advice on whether the types of accommodations you're asking for would be reasonable or not. Undue hardship is a standard, but it does not require the employer to change the job in a way that would make the job basically irrelevant and not productive for the employer to have someone even do it. Now, if your request is denied, if the employer, you think that you have been the victim of a failure to accommodate, then seek out legal advice, because this can be grounds for wrongful dismissal. Like I said, it's often part and parcel with a wrongful dismissal. We see a lot of people get fired because they've disclosed they have medical issues, they've disclosed they need accommodations, or they're on a sick leave, they're coming off a sick leave. That's very common cases that we handle. And it always involves this issue of whether the employer did an accommodation or not. So for a takeaway, we're at the end. For a takeaway, the duty to accommodate is a shared responsibility between you and the employer. You cannot put it completely on the employer. You will lose your case if you are not seen to have been acting in good faith in engaging with the employer, giving the reasonable information they need. Now, there are limits, but undue hardship is real. The law sets a high bar for what's required. And again, it can be very high for employers like the federal government, provincial governments, and large employers. Now, you have significant rights and the employer can't brush them aside, but again, you do have to engage in the process. All right, that's all I have for talking about that. I would say I appreciate people who've showed up here on the stream. Put your questions in if you have any. I had an interesting thing today. It kind of fits in with our topic. This first time I've done it, represented a federal worker, a federal non-unionized worker in a grievance process. So normally it's kind of unusual. Normally there is not a grievance process for non-unionized workers. The federal government is unique in that it does have grievance processes for non-unionized federal employees. When you're a non-unionized federal employee, you can hire your own lawyer, which is what my client did. And we're going through the process. I've never done it before. I actually told this client I've never done this process before, and that it would be somewhat of a guinea pig situation. But the client was fine with that. They really wanted me to represent them, and they've been happy so far with what I've done. Very happy. And we had so we've done submissions, and now we did a grievance hearing today. Was it this morning? I think it went well. And then we have to wait. We have to get some more things in, and then we wait for a decision on the grievance. This would be a grievance at the department level, and then what happens with these cases if the grievance is not successful. So this is a situation where someone was terminated, and we're doing a grievance saying that it was an unjust termination and trying to get the job reinstated or the person put back in a different role, equivalent level job, maybe in a different department or something like that. If it's not successful, if the grievance is not successful, then there is a board that hears these cases for unionized and non-unionized workers. It's basically the same as going to like the Social Security Tribunal. It's a special board tribunal set up to adjudicate these cases for federal government workers. It's interesting, but hope to do more in the future. This was a good one to kind of learn. You learn when you do these how intricate and complicated sometimes these processes are. They're very hard to understand what to do, because you have to go through different statutes that set out timelines and deadlines to respond, to do this, to do that. It's not always clear online what to do. So, in fact, as I thought, like the only way to really learn what to do in these cases is to start doing the cases. And the first few, you just sort of go along, try to figure out all the steps as you go. And now once you know the process, well, then the next time it's going to be much easier. Okay. Let me see. So just so you understand, like with these processes where there's grievances, it means that there is not the same rights to just file lawsuits. When your employment is governed by statutes and things like the federal public service, you just can't file a regular lawsuit like anyone else. I'm trying to think of other examples. I know that the federal public service would be one. There may be others that I'm not thinking of where you have your rights are kind of curtailed a little bit. It's not the same where you can just run out and file a lawsuit. Now you can file a lawsuit with the federal public service, but it is beneficial for you to first go through. I think most courts would not be pleased if you didn't first go through the process that's set out through the grievances and through the board that oversees these types of claims. Okay, let's see if we got anything new on the forum. One of the staff pointed out, they watched my video yesterday. Not sure if any of you were here, but somehow in my mind, I thought it was Wednesday. So I was saying, see you folks, we'll see you next week. So I'm sure people are like, what is this guy talking about? Yeah, no, today is Wednesday. Yesterday was Tuesday. So I did Wednesday's show yesterday, and today I'm doing what was supposed to be Tuesday's show, just for those of you that are keeping track here. Not sure why I got it into my mind that yesterday was Wednesday, but there you go. Nope, there's nothing new. No new posts on the forum. So it's a slow week for the forum. I'm doing a much better job keeping up on it than I have ever in the past. I'll give some more time here. If people have questions that have showed up, happy to answer them. If not, today is Wednesday, so it will be my last day. I've had a very long day with working. Looking forward to taking a break this evening, maybe heading to Costco. Not sure if any of you are like, the time to go to Costco is Wednesday evening, Tuesday, Wednesday evening. There's nobody there. That's the time to go. So I'm probably going to head to Costco, pick up a few things, and enjoy my evening. We've only got the summer is basically over. We've only got a few. We literally only have a few weeks left, maybe, of summer. When does summer officially end? September. Okay, someone's got a question here. Let's have a look. Quick question: are the episodes by any chance still numbered? Yeah, they technically are. I have to go in. What happens a lot of time is I'm quickly getting ready to do to get ready to do this, and I don't put the episode number in when I'm logging it in. But what I'm going to do is I'll go back and make sure all the numbers are in there. That's pretty easy for me to do. But yeah, they're technically supposed to be numbered, but I'm my own producer, so I'm like doing it kind of fast and not always putting the number in. But I will do that. Makes it easier to refer back to the episodes for sure. Okay, let me see if there's any other news that I'm missing. So there's another question here. Any way to figure out the date of the episode? Not really. They kind of go, they're in chronological order. So if you go to the website, if you go to YouTube and you go to live, you can kind of go back and see, where the episodes all line up. I agree it would be good to have like a master list. That is probably something we could redo. I still do have the private members area. I'm not keeping it up as much now that I don't have like a full-time person managing it. Probably at some point I'll circle back around and get that fixed up and have a master list of all of the episodes we've done. I'm very happy if there's an episode that people liked. I'm very happy to redo the topic again. We're pretty open in what we're going to do on the live show here. I plan on this fall getting back to shooting just regular YouTube videos as well that just are more produced a little bit to post up there. This live show is just more meant to be kind of a freewheel, answer people's questions, that kind of thing. Okay, let's take a peek. So the private members area, I'll show you what that is. Let me bring it up. This was something I developed years ago. So we used to do the webinars that I now decided to switch over to YouTube on YouTube Live. We used to have them, they were private. So they weren't live like this. They weren't live streamed. Well, they were done live, but they were done just through a webinar, through Zoom webinars. And then we would put the recordings behind a paywall, although you don't have to really pay to be a member, but they were that way. So that's how people access them. I decided just to move away from that and just make it more easy and open for people to find it on YouTube. But let me just share I'll show you where this is at here. I just have to share my screen. So if you go to our website, I'm almost there. That didn't work. Let me try that again. There we go. Why isn't that? Oh, there it is. Okay. Sorry. So this is our website. If you go to the Learning Center in membership, it takes you here. This is the membership area. So you can log in here. You sign up here. Once you get behind the membership, let me see if I can get in here to show you what it looks like. Don't even remember my password here. Where is it? Is it this one? No. Yeah, I don't have my login right off the top of my head here. It is, let me see. I think I know what it is. Plus, it's going to look different from my login from yours as well. Yeah, there it is. I think this is it here. See if this works. Nope. All right. That's not working. It's pretty bad. I can't log into my own membership. I haven't logged into it for a while. I'll do this another day where I can give you kind of an overview of it. Yeah, it's funny I can't log in. Let me see if I can get into it a different way. It's probably because I'm not a member. I can only get in the back end. Let's try that again. I'm going to try it a different way. Let's see. All right, here we go. Oh, double. It's always something. Okay. I got to do it where they texture the code. So there we go. I guess it's for my own protection. Yay, I'm back in the back end here. Now, I don't know what it looks like for you guys. I'm looking at what it looks like for me. Yeah, it's going to look very different for you. So I don't know if this is that helpful, honestly. But suffice it to say, yeah, this is just going to, this is not going to be the right thing to show you. So what I would encourage you to do is just go and where I showed you before, go and sign up and you will get an invite to go back into the membership area. So what's back there, just to describe it, is let's see if the website shows anything on it. I don't, maybe it doesn't actually. Learning Center. No, I guess it doesn't show anything extra. So when you log into the membership site, it just will give you, you'll have different options there to, well, first of all, there's a course you can get access to, the course that goes over how to apply for CPP disability. Probably going to update that at some point, but there's like 25, 30 videos going through how to apply for CPP disability. So that's in there. I cover different aspects of a disability claim and things you want to think about. That's all also in there. There's all our old videos from when we did back when Maddie was working with me and we were doing this by webinar. She would upload all the videos to our membership area so you could see all the past videos. That's what most people used it for, is to get the catalog of all our past live streams that we did. But now those are all just on YouTube to make it way easier. All right. Well, I'm going to leave it there, folks. We will be back. Now, this is actually Wednesday today, so today is my final day. I will be back next week. I'm not sure if there's a vacation day in between here and when I come back again, but we'll have to see. We'll put out the schedule in the email that goes out. So hopefully I'll see you all folks all back here. I appreciate you showing up and have a good weekend. Bye, folks.